391, which states that any claim for death or injury to any passenger or third party pursuant to the provisions of this chapter shall be paid without the necessity of proving fault or negligence of any kind, provided that for purposes of this section, there are requirements. Like for example, letter A, the total indemnity in respect of any person shall not be less than 15,000 pesos. So if you're going to get a third-party insurance, the insurance shall not pay less than 15,000 pesos. Letter B, the following proofs of loss, when submitted under oath, shall be sufficient evidence to substantiate the claim of one of the requirements is one, police report of accident; two, in case of death, death certificate and evidence sufficient to establish the proper payee, or the medical report and evidence or evidences of medical or hospital disbursement in respect of which refund is claimed. So for example, official receipt or certification of the physician or the record of the hospital. So this is an example of the police report wherein you can see here the details of the accident. So that would really matter to prove the incident. And this is an example of a car crash which I was involved in last October 7. So what happened here is that we met an accident in Kitagum, and then when we applied for the insurance of the company, and also when the owner of the vehicle that we also bumped asked for police report. So we were able to obtain the police report, and thus the insurance company paid the owner of the other vehicle and also paid us for purposes of claiming insurance. So letter C, claim may be made against one motor vehicle only. So one insurance contract, one vehicle. So that's the policy. You cannot get an insurance contract with multiple vehicles. In the case of an occupant of a vehicle, claim shall lie against the insurer of the vehicle in which the occupant is riding, mounting, or dismounting from. For example, if you're gonna ride a bus, and then when you are let's say about to dismount from the bus, and then the bus suddenly accelerated, and you have been injured, so you can actually claim from the bus company, in which the bus company will ask the insurer or the insurance company to pay you. In any other case, claim shall lie against the insurer of the directly offending vehicle. In all cases, the right of the party paying the claim to recover against the owner of the vehicle responsible for the accident shall be maintained. Section 392 states that no land transportation operator or owner of the motor vehicle shall be unreasonably denied the policy of insurance or surety bond required by this chapter by the insurance companies authorized to issue the same. Otherwise, the LTO shall require from said land transportation operator or owner of the vehicle in lieu of a policy of insurance or surety bond. This policy of insurance, this surety bond, this is where you deposit if you choose not to, if I'm not mistaken, if you choose not to avail or get a insurance policy, I think you can deposit to the commissioner. So it states here that in lieu of a policy of insurance or surety bond, a certificate that a cash deposit has been made with the commissioner such amount required as limits of indemnity in Section 390 to answer for the passenger and/or third-party liability of such land transportation operator or owner of the vehicle. So, let's say for example you have a bus company, you are an operator of a bus company. So, you you cannot unreasonably be denied the policy of insurance or surety bond required by this chapter, by the insurance companies authorized to issue the same. So if you're gonna apply for an insurance, third party compulsory motor vehicle liability insurance, then there's no reason for the insurance company, if he is authorized, or if it is the company, if the company is authorized to issue the same, then the company cannot reject or deny you. So let's go to 39. Let's continue. The authority to engage in the casualty and or surety lines of business of an insurance company that refuses to issue or renew without just cause the insurance policy or surety bond therein required shall be withdrawn immediately. So the authority to engage in the casualty and or surety lines of business of an insurance company that refuse. So if the insurance company refused you to issue or renew without just cause, that policy or surety bond therein required shall be withdrawn immediately. So let's go to section 390. It states that no cancellation of the policy shall be valid unless written notice thereof is given to the land transportation operator. So if the insurance company is going to cancel your insurance company, so it must notify the operator or the owner of the vehicle, or and to the LTO. The company must notify also the LTO for said cancellation. So prior to the intended effectivity date thereof. So before the effectivity. So if next year the insurance company is going to cancel you for just cause or for authorized cause, it shall notify you and the LTO before the effectivity date. So if next year January, it should be the notification should be given at least before not at least like for example December this year. Upon receipt of such notice, the LTO, unless it receives evidence of a new valid insurance or guarantee in cash or surety bond or an endorsement of revival of the cancelled one, shall order immediate confiscation of the plates of the motor vehicle covered by such cancelled policy. So if your policy is cancelled by the insurance and you still drove your car and you met an accident, your motor plates, the plate of your vehicle will be confiscated. The same may be reissued only upon presentation of an insurance policy or that a guarantee in cash or surety bond has been made or posted with the commissioner. So if the cancellation in section 394, if the cancellation of the policy or surety bond is contemplated by the land transportation operator or owner of the vehicle, he shall, before the policy or surety bond cases to be effective, secure a similar policy of insurance or surety bond to replace the policy or surety bond to be cancelled, or make a cash deposit in sufficient amount with the commissioner, and without any gap, file the required documentation with the LTO and notify the insurance company concerned of the cancellation of its policy. So I think that's very understandable. If the cancellation of the policy or surety bond is contemplated by the land transportation operator or owner of the vehicle, he shall, before the policy